Hi, it's Bronson again. So you've been denied long-term disability. What do you do now? And I get this question a lot. The best advice I can give to a person is to slow down, to look at the denial letter that you have, to evaluate why your claim has been denied, and to most likely contact an attorney. And here's why. In disability cases such as long-term disability, your claim is governed most likely by federal law. That's under the Employee Retirement Income and Security Act. It's a law which has very specific regulations, rules, and it is full of pitfalls. And when someone is denied long-term disability, they are given the right to appeal that decision. Now, usually when we think of an appeal, we think of going to some neutral third party who's going to make a fair decision about their claim. That's not what this statute requires. This statute requires the claim to go back to the insurance company and have the insurance company make a new decision. Oftentimes, I will get people that call me after they have filed their appeals and have exhausted their appeals and are ready to file a lawsuit against the carrier. And often I have to look at those claims and tell those people, I can't help you, or I can help you, but there are some significant problems with your case. And here's why. In a long-term disability case, which is governed by the Employee Retirement Income and Security Act, or ERISA for short, the only information you can later point to when you're in a legal case in federal court is information provided to the insurance company during the appeals process. So the insurance company wants you to file a quick appeal. They want you to send an angry, emotional letter outlining why they have been so unreasonable in their denial and why they were so wrong in denying your claim. They love that. Why? There's no evidence attached to that. That's just your thoughts, your emotions. What's important in a long-term disability appeal is to include facts, objective evidence. And often we will use things such as functional capacity evaluations, where a physical therapist evaluates your ability to do certain functions. We'll use independent medical examinations with specialists. Oftentimes they've had a nurse consultant or an in-house doctor look at your case. We have a neurologist look at your case if it's a neurological case. We have an oncologist look at your case if it's a cancer-related case. We have an orthopedic or a neurosurgeon look at your case. So we use independent medical examinations, we use functional capacity evaluations. In a psychological case, we'll use a psychologist, we'll use neuropsychological testing. We will build the facts which help your case. And then we'll tie that all together by having you testify in a deposition. We'll invite the insurance company to come to our office. They often don't come, but we invite them. We invite them to ask questions. We want the record to reflect that we've been open, that we've done everything we could to establish the facts of your disability, the reasons for your disability, the objective evidence for your disability, and we tie that together in our appeal. Now, when we've done that, if the insurance company decides to still deny your case on appeal, then we are prepared, we are ready to go to federal court and win your case.